everyone, welcome to iExamBee. I'm Neha, your law faculty at iExamBee's LegalBee. आज मैं इस वीडियो में डिस्कस करने वाली हूँ हमारा मॉक टेस्ट सीरीज जो ऑलरेडी हमने स्टार्ट किया है काफी समय से, और हम आपको प्रोवाइड कर रहे हैं डिफरेंट टाइप्स ऑफ MCQs questions with respect to the various competitive exams. So in this video also I'll be continuing ahead with that, and we will be looking onto the various MCQs with respect to the Contract Act. But before that, do remember to subscribe to our channel and press on the bell icon so that you can stay tuned and stay updated. आप हमें जरूर कांटेक्ट करें अगर आपको कोई भी क्वेश्चंस हो या क्वेरीज हो या आपको कुछ भी जानना हो किसी भी कॉम्पिटिटिव एग्जाम के बारे में, तो आप हमें बिल्कुल कांटेक्ट कर सकते हैं थ्रू दिस ईमेल आईडी, या फिर आप हमें कॉल भी कर सकते हो इस पर्टिकुलर नंबर पे। इसके अलावा आप हमारी वेबसाइट को विजिट करो जहाँ पे कि आपको बहुत सारे कॉम्पिटिटिव एग्जाम्स के बारे में इन डिटेल पता चलेगा। सो डू रिमेम्बर टू सब्सक्राइब टू द चैनल, स्टे ट्यून्ड एंड स्टे अपडेटेड। एज आई ऑलरेडी मेंशन, आज हम इंडियन कॉन्ट्रैक्ट एक्ट से रिलेटेड मॉक टेस्ट सीरीज कंटिन्यू करने वाले हैं हमारा, और इसके अंदर हम कवर करेंगे ऑफ सर्टेन रिलेशनशिप्स resembling those created by law and of the consequences of breach of contract. So these are very important concepts under the Indian Contract Act of certain relations resembling those created by contract. So इसको हम other words में quasi contracts भी कहते हैं। And what are these quasi contracts? ये वैसे contracts होते हैं जिनमें की पार्टी खुद में जाके एंटर नहीं करते हैं एक दूसरे के साथ। This is basically what the law has imposed on the parties. So that is why these are termed as certain relationships resembling those created by contract, because in the contract the parties voluntarily and willingly they enter into it. However, these are the contracts which the law has imposed on the individuals, and of the consequences of breach of contract, wherein whatever terms जो parties agree किए थे, whatever obligations they were supposed to fulfill in a particular contract, they have non-performed with respect to that. They have breached the terms of the contract they agreed into, and so what will be the consequences of that? These have been provided under the Indian Contract Act. Now moving on to our first question of discussion for today, that is Contract Act lays down the provisions relating to compensation for breach of contract where. So compensation for the breach of contract under the Indian Contract Act, that can be given in what situation basically as per section 74 of the Act, and you can see the various options over here, and the correct option for this particular question is where the penalty is stipulated for, which is our option number A. Section 74 already हमने क्वेश्चन में देखा इस प्रोविजन से रिलेट करता है, जिसमें कि it has been laid down compensation for breach of contract where penalty stipulated for, where the penalty has been basically you can say pre-decided, they have been stipulated. So when a contract that has been broken और एक sum जो है उस contract में named है जो कि वो amount होगा जो कि पे किया जाएगा in case of breach, or if the contract contains any other stipulation by way of penalty, the party who is complaining of the breach, he is actually entitled to receive that from the other party who has actually broken the contract. So whether the actual damage has actually been proved to have been caused or not, he will be receiving from the other party who has broken the contract reasonable compensation, and that compensation cannot exceed the amount which has been so named, or as the case may be the penalty which has been stipulated for. So basically these are talking about what liquidated damages. What are liquidated damages? Which the parties have already beforehand decided and they have put that in the terms of the contract. So this is what section 74 of the Contract Act provision lay down करता है. Question number 2 is talking about a party can claim compensation for any loss or damage caused to him by breach of contract which. So when can a party can go ahead and claim compensation? वो कब claim कर सकता है किसी भी loss या damage के लिए जो उसे cause हुआ है with respect to breach of contract? And you can see the various options are naturally arose in the usual course of things, is remote but resulted in damage being sustained by the party. Parties knew when they made the contract to be likely to be the result from breach either A or B or C, either A or C, and the correct option is E, which is either A or C. A क्या है हमारा, which naturally arose in the usual course of things, or C, which is the parties knew when they made the contract to be likely to result from breach. So जो भी party claim करेगी compensation किसी भी loss या damage जो उसको suffer हुआ है, sustain हुआ है, or which has been caused to him because of the breach of contract, the non-performance of the contract by the other party, then he will be getting compensation with respect to the loss or damage which actually naturally arose in the course of the things. मतलब breach होने पे वो naturally उसका consequences होगा, उसके वजह से ऐसा loss होगा, so that is basically what is naturally arose in the course of the things, or which the parties actually knew when they were entering into the contract that it will be the result from such a breach. So in either of the situations, so compensation for the loss or damage caused by breach of contract, section 73 इससे related provision lay down करता है, जहाँ पे की mention है when a contract has been broken, the party who suffers by such breach is entitled to receive from the party who has broken the contract. Obviously जो aggrieved party है उसे compensation मिलेगा from the other party who has broken the contract. Compensation for any loss or damage caused to him thereby which naturally arose in the usual course of the things for such breach, or which the parties knew when they made the contract to be likely to result from the breach of it. Such compensation is not to be given for any remote or indirect loss or damage sustained by reason of such breach. Over here I would like to highlight कि इसीलिए it is very important कि आप बेयर एक्ट की थरो रीडिंग करें, क्योंकि ये क्वेश्चन जो है basically this is what we say it is a section based question. Now, moving on to our third question, that is a person who finds goods belonging to another and takes them into his custody is subject to the same responsibility as a who? Bailey, pawnee, pledgee, either A or B or C or man of ordinary prudence, and the correct option is A, which is Bailey, जो कि हमारा section 71 में दिया है responsibility of finder of goods. So what is the responsibility of the finder of goods? जिसको कुछ मिला है जो उसको belong नहीं करता है. So a person who finds goods belonging to another and takes them into his custody, he is subject to the same responsibility as that of a bailey, which the Contract Act lays down that there are certain responsibilities of a person as a bailey. So the same responsibility is that of the finder of the goods. Section 71 इससे related provision lay down करता है. Now moving on to our question number 4, which is talking about Ankit, a tradesman, leaves goods at Sushil's house by mistake. Sushil treats the goods as his own. Sushil dash. So which of these is the correct option from the various options which you can see on the screen? And the correct option is A. Sushil is actually bound to pay Ankit for them. Why? Because section 70 says obligation of person enjoying the benefit of non-gratuitous act. So one act is a gratuitous one is a non-gratuitous one. In a non-gratuitous one, there is no intention to do something to the other without any consideration. So यहाँ पे अंकित जो एक ट्रेडमैन है उसने अपने गुड्स को सुशील के हाउस पे गलती से छोड़ दिया था. सुशील ने उसको अपना गुड्स मान के उसको यूज किया, तो उस केस में सुशील की ये ड्यूटी बनती है, रिस्पॉन्सिबिलिटी बनती है, he is obliged that he should pay Ankit. So where a person lawfully does anything for another person or delivers anything to him, not intending to do so gratuitously, यहाँ अंकित का कोई इंटेंशन नहीं था gratuitously उस सामान को सुशील के यहाँ छोड़ने का ताकि सुशील उसे यूज कर सके, and so such other person enjoys the benefit thereof, then he is bound to make compensation to the former in respect of or restore the things so done or delivered. So he has to either compensate the other person or he has to restore the thing so actually done or delivered. So either of these things he has to do. Now हमारा fifth question है, as per the Contract Act, what is the liability of a person to whom money is paid or thing delivered by mistake or under coercion? And the correct option is E, either A or B. तो हमारा A क्या है? He must pay for it or he must return it. Section 72 इसके बारे में provision lay down करता है and it mentions liability of person to whom money is paid or thing delivered by mistake or under coercion. So what will be his liability? The person to whom the money has been paid or anything delivered by mistake or under coercion, he must either repay it or return it. Section 56 of the Indian Contract Act is based on which maxim? Section 56 पहले किस चीज से related है वो आपको पता होना चाहिए और तब आप बता सकते हो कि जो maxim applicable होगा इस section 56 पे. This talks about the doctrine of frustration. Section 56 में doctrine of frustration नहीं mention है, but it is mentioned with respect to the agreement to do impossible act. So which of these maxim basically relates to section 56? And the correct option is C, which is less non-cogent ad impossibilia. So maxim means the law will not compel a man to do what he cannot possibly perform. This section deals with those cases where performance of a contract has been frustrated and the performance of it has become impossible to perform due to any unavoidable reason or condition. Our next question, that is question number 7, and it says an agreement becomes a contract if. So when does an agreement becomes a contract? If it is by free consent of the parties are competent, it is enforceable by law, all the above and none of the above. And the correct option is C, if it is enforceable by law. Section 2 clause H of the Contract Act mentions an agreement enforceable by law is a contract. So an agreement becomes a contract if. So when will an agreement become a contract? When it is enforceable by law. अब आपको यहाँ लग रहा होगा कि all the above भी तो हो सकता है क्योंकि there should be a free consent of parties या competency of the parties should be there. But it is not correct. It is basically a confusing option which is given to you. On the face of it हमें लग रहा है कि वो सारे options correct है, but वो सारे options correct नहीं है. And क्यों नहीं correct है? क्योंकि पहला तो आप definition से ही देख लो कि an agreement enforceable by law, that is basically a contract. So for that enforceability का क्या मतलब हो गया कि आप कोर्ट को अप्रोच कर सकते हो for getting the remedies and all in case there is a breach of contract. So enforceability is that element which makes an agreement a contract. और enforceability होने के लिए या the things which are essential with respect to the enforceability is the free consent of the parties, the competency of the parties and all which is there under section 10. So over here the correct option is C. Now next question, that is question 8, is talking about what are the remedies for breach of contract. If there is a breach of contract, any of the parties has non-performed its respective obligations, promises in a contract, what are the remedies जो law provide करता है उस aggrieved party को? And the correct option is D, all the above. Unmaking of the contract, enforcement of exact terms of the contract, monetary compensation allowed to the aggrieved party. तो आप देख सकते हो unmaking of the contract or cancellation of the contract or termination of the contract, which is also known as rescission. Then damages wherein monetary compensation is being given to the aggrieved party. Quantum meritum, that is as much as is earned. Specific performance means where there should be the exact enforcement of the terms of the contract, and damages, they are not actually adequate remedy, or you can say monetary compensation is not sufficient. जहाँ पे कि जो exact terms जो party ने agree किया था, that needs to be performed. And then comes our injunction, that is basically the order of the court which is giving a direction to a person to do or not to do some act. So these are the various remedies which are available to an aggrieved party in case the contract is breached by the other party. And now moving on to our question number 9, which talks about Manjula enters into a contract on 1st of January 2022 with Ashish to sell her laptop. As per the terms of the contract, Manjula agreed to sell the laptop on 3rd of January 2022 and Ashish agreed to pay an amount of 50,000. But before that only, Manjula sells her laptop to Indresh on 2nd of January 2022, and so this amounts to mutual breach, actual breach, anticipatory breach, both A and B, both A and C. And so the correct option for this is C, which is anticipatory breach. Types of breach की अगर हम बात करें तो actual breach क्या होता है, on the scheduled time of performance होता है, और anticipatory breach की बात करें तो वो before the time of performance होता है. और यहाँ time of performance जो है या day of performance 3rd of Jan था, उसके पहले ही मंजुला ने लैपटॉप इंद्रेश को सेल कर दिया 2nd को. So there is basically this will be amounting to an anticipatory breach where the party has disabled himself from the performance. And now moving on to our last question for today's discussion, that is question number 10, which talks about section 68 to 72 of the Contract Act deals with the provisions relating to. So which of these things have been talked about under these particular sections? And the correct option is A, which is quasi contract. So you can see under section 68 to 72, basically it has been talked about certain relationships resembling those created by contract, which we also refer to as quasi contract. ये basically imposed होते हैं by law for the benefit of another even in the absence of a contract, जैसा पहले ही डिस्कस किया क्वेश्चन में. And under this there are various provisions are, first is with respect to claim for the necessary supply to a person who is incapable of contracting or on his account. So the other person is entitled to be reimbursed from the property of such incapable person. Then reimbursement of the person paying money due to another in payment of which he is actually having an interest, and so he will be entitled to be reimbursed by the other party. Obligation of the person enjoying the benefit of non-gratuitous act bound to make a compensation in respect of or to restore the so done or delivered. Responsibility of finder of goods same as that of the bailee, and he has to take care of the goods as a man of ordinary prudence. And liability of the person to whom the money is paid or thing delivered by mistake or under coercion, so he has to repay or return it. So these are the various provisions with respect to quasi contract under the Indian Contract Act, which basically doesn't uses the term quasi contract over there, but uses the term certain relations resembling those created by contract. So with this, we come to an end of our discussion of the mock test with respect to the Contract Act. Stay tuned to our channel as we'll be coming up with the other mock tests and various other contents. Stay tuned, stay updated, and make your preparations 50% faster with us at iExamBee.